Thank you, Mr. Speaker. H.R. 2947, the Financial Institution Bankruptcy Act of 2015, amends the Bankruptcy Code to establish a process for the expedited judicial resolution of large financial institutions to soften the disruptive effects of their collapse. As we all know, the Great Recession was triggered by the widespread issuance of and limited regulation of high-risk and possibly fraudulent mortgage-backed securities, fueled by rate and predatory subprime mortgages. These securities were issued without regard to thoughtful underwriting standards, causing a housing bubble that trapped countless homeowners in unaffordable mortgages and leading to a massive wave of foreclosures that resulted in the worst financial crisis since the Great Depression. In the wake of this crisis, the President signed the Dodd-Frank Act into law to provide comprehensive measures to reduce systemic risks through heightened financial stability requirements for large financial institutions. Among many other requirements, Title I of Dodd-Frank requires that certain large financial institutions have living wills to ensure a rapid and orderly resolution in the event of material distress or failure. Title II of the law provides for an administrative process to wind down these institutions to avoid adverse effects on the entire financial system. But there is no such process under the current bankruptcy law, and that's why I applaud Congressman Trott and the chairman of the full committee, Chairman Goodlatte, for addressing this concern by offering this legislation to revise the Bankruptcy Code to establish a specialized form of bankruptcy relief that would facilitate the expeditious resolution of large financial institutions and minimize the disruptive impact of a company's collapse on the financial system. The legislation largely accomplishes this goal by establishing a resolution process authorizing a court to provide relief by transferring a debtor's assets to a bridge company under an expedited timeline while adverse effects of the bankruptcy on the financial system. While these aspects of the bill are commendable, I remain concerned, however, that this legislation lacks a funding mechanism to allow the federal government to provide liquidity to the company, which is a key difference between an orderly resolution under Dodd-Frank and the resolution contemplated by H.R. 2947. In a typical bankruptcy case, the debtor's reorganization may be funded by private parties or by the federal government, as illustrated by the General Motors bankruptcy. In many instances, liquidity provided by the U.S. government to prevent the collapse of financial institutions has either returned a profit to the taxpayers or is likely to be repaid. Leading bankruptcy experts have found that providing liquidity to distressed financial institutions, quote, is essential to successfully resolving the firm without creating undue systemic risks, end quote. This critical mechanism has prevented the collapse of several major financial institutions without cost to the taxpayer. Lastly, I would caution against efforts to combine H.R. 2947 with legislation that would strike Title II of the Dodd-Frank Act. As the National Bankruptcy Conference has observed, laws currently in place, such as Title II of the Dodd-Frank Act, should remain in effect because the ability of the U.S. regulators to assume full control of the resolution process to elicit the cooperation from non-U.S. regulators is an essential insurance policy against systemic risks and potential conflict and dysfunction among the multinational components of these institutions. I would also note that Title II of the Dodd-Frank Act serves as a valuable backstop to the bankruptcy process should this bill become law. Notwithstanding these concerns, I thank once again the gentleman from Virginia the gentleman from Michigan, and also my friend and chair of the relevant subcommittee, Tom Marino from Pennsylvania, for their leadership on this issue and the bipartisan process for developing this legislation. I also thank the Democratic and Republican counsels of the Judiciary Committee, Susan Jensen and Anthony Grassi, for their tireless work and substantive expertise in developing this legislation. And with that, I will reserve the balance of my time.
The gentleman reserved.